Welcome back, corporate warriors. This is attorney Anitra, and this is your final session of legal therapy. This has been a Trill MBA TakeOver. No, I am not a licensed therapist. Please don't go around telling people that I am. But I am a licensed attorney, going into my 7th year of law practice. And I know I first started practicing going against big corporations and the big defense firms that they hire was so scary, honestly. And there was a time where I thought I was too empathetic and too soft to even be an attorney. I remember when I first started practicing, I went up against one of the most feared employment law defense attorneys in the area. But you know what? After about a year of fighting, she came to the table. And although the streets were whispering that she never gave up any money, I was able to come to the table with a 6-figure settlement offer. That's when I realized we don't have to be afraid. We just gotta have time. And guess what? I got time today. Let's talk about strategy when you know things are going down at work and you've got to fight back. Let's unpack that. I've taken a case where we knew that things were going to eventually get to a point where the employee had to fight back. We were hoping that they didn't get there, but unfortunately it did. So me and my client started working together. I sent out a few communications, and like clockwork, that PIP meeting they had scheduled canceled at the last minute. And y'all, tell me why the head of HR forgot that her calendar is public. We saw the meeting that she had scheduled with their legal team. Yeah. So how do we get corporations to react that way? How do we turn the table so that we're the ones on top? We're the ones with more power. Have you ever felt like you just did not have what it took to really stand up for your rights and fight against a huge corporation? Well, guess what? There are areas where they are not that strong in. There are some vulnerabilities with being that big. A giant, so to speak, still has weak spots. We just got to figure out exactly where those are. And that's what I want to talk to you about today, because I got time today. Okay, so today's episode is for the corporate warrior who knows that she is in the middle of some crap at work. Like there's no trying to negotiate your way out of it. There's no trying to explain it away. You are in the thick of things, and it's time for you to make a decision about what you are going to do next. Now, you can pick up, you can quit and just leave. And we all know that when we walk away from a situation, most immediately, there is relief. You don't have to deal with the stress of the day-to-day anymore. You don't have anybody breathing down your neck. I get it. No judgment. But my question to you is, what are you going to do the next time? Do you have the skills? Do you have the know-how that when you walk into the next place of employment for you and it happens again, that you'll know what to do? That's why we have to have strategy, because this isn't just for this job. This is for your career. This is for your life, to know how to fight back and take advantage of the laws that are here to support you. And that's what we're going to talk about today. I got time today. So we can all agree that when things go really badly at work, it's awful. It's painful. And we just want the pain to stop. You know, I had a client who just couldn't seem to do right at work, even though she was making the company a lot of money. And I would listen to the voice recordings that she gave me, and she would have the same tone of voice. And it was obvious that she wasn't ecstatic about what was happening, but she wasn't being aggressive at all. And I actually heard the HR representative call her abrasive and start yelling at her. And the reason why, especially as Black women, is that when we allow other people to feel uncomfortable, when we don't go out of our way to be bubbly and upbeat to make everybody at ease, they take offense to that. That is offensive to a lot of people, and they'll begin to act aggressively towards you for simply making them uncomfortable with the truth that I'm not happy here. And so in that particular case, I kept searching for the thing. There's always a thing, the reason why, something that is very unsettling to the people around you who are discriminating against you. There's fuel for that. And I figured it out and finally got them to admit that she was the highest paid person in her position. She out-earned her white colleagues, and there was always this resistance in her situation because of that. And so we were left with no choice but to negotiate a settlement agreement. And by the time I worked with her and worked with the opposing counsel, we decided we had time on that day and we settled. And so the pain, we can get it to stop very quickly. But if you push through it and learn the strategies, then you too can leave on your terms. Okay, this is what I want us to do. We've got to put on that mindset that you've got time today. Yes, the feelings are very uncomfortable. And we can talk about that another time, all the range of emotions that you'll go through in one of these situations. But when you put on your hat and you say, I've got time today, you are telling yourself that you will rise to the occasion and face the ugly truths of what's around you. And in the process, you're going to gain the skills to always protect yourself. So when we talk about strategy, we're talking about this journey of you being on a road to your career development. And so my thing is, if your employment is like a journey, or it's like a road trip, that I want you to get off on an exit that you want to get off. But sometimes we have to make an emergency exit. And there are 3 exits that I want you to look for. The first one is a calm work environment. Sometimes you just need to make a pit stop real quick and get things back on track. I remember a potential client came to me and I was ready to just bring all the smoke to her employer. But something made me stop and say, hey, go back to your supervisor. Let your supervisor know how you feel when that happened, because he had singled her out in a meeting and really humiliated her. Go to him and tell him how you feel and see what happens. And sure enough, her supervisor was deeply apologetic and went out of his way to fix what had been broken. And since then, she's had the confidence and the comfort level to excel, to be one of the top performers, and she's been promoted several times. So not in every single situation will you need to fight to the death and try to create a legal escape that we're going to talk about in other 2 situations. But here, she was able to patch things up. Now, the reality is 10% or less of these situations are going to end up with the employer fixing the situation. That's just the reality. So you're going to have to be prepared to take one of the other 2 exits. The second exit that you can take, and it's really my favorite exit, the second exit is a contract for a settlement, also known as a severance agreement. I favor severance agreements or contracts for settlements because you don't have to pay for the expenses of litigation. You don't have to have a long, drawn-out process. This can be done in a few weeks or a month or so. And you also get to build in some terms that protect you. And one of the things that I always include in a settlement agreement is a way for the other side not to talk about what happened. You guys are going to be observing some confidentiality about your time there. So you want to be forward thinking, not just today. Yeah, the pain can stop today, but if you walk away and you don't actually protect your reputation, they could also prevent you from getting jobs down the line. So we're not just talking about an immediate impact on your salary. We're talking about a fracture of your future earnings, and that's not what you want to do. So you can really control a situation by getting into a contract for a settlement. Now, if that still doesn't work, your third option is a claim for discrimination. We talked in an earlier episode about the EEOC process, right? If you're going to pursue a federal discrimination claim, you have to stop at the Equal Employment Opportunity Commission first. That is called exhausting your administrative remedies. The advantage of that is that the EEOC is a free process and you can technically do it yourself. I do guide the process for my clients. I write the charge. I talk to the EEOC. My client doesn't have to do a lot if they hire me as they go into the EEOC process. But technically, you can do that on your own. And when you have a mandatory free process, that really does put the power back into your hands. You just have to get to the point of having the courage to initiate a claim. And of all the instances of bullying, the World Bullying Institute says less than 2% of people will actually even file a claim who experience workplace bullying. So we have to get to a place where we're comfortable with moving forward. And I know the scary thing is, and the thing I hear from every potential client is, I can't prove it. I can't prove it. I can't prove it. And I tell them, listen, that's my job. Your job is just to feel. Did you feel discriminated against? Did you feel harassed? Did you feel like somebody was watching you more than they were watching your colleagues who don't look like you? That's the information we need. And the proprietary process I've created extracts that information out of you. I know how to walk through and systematically teach you how to start recognizing the things that were happening to you that I could use as evidence. You don't know that, and why should you? You've been putting in work to be the best that you can be in your profession. You're trying to get to the top of your game. At the same time, I've been doing that for this field and in this area of law. So don't feel bad if you don't know how to prove it. That's what I got to do. So let's talk a little bit more about this filing a claim. What does that entail? Well, you have the really big statute, the Civil Rights Act of 1964, and specifically Title VII of that act. That's where you have all your equal employment opportunity laws for the bulk of what we know as employment discrimination law. That means race, color, ethnicity, religion, and sex are all covered under Title VII. Additionally, some other acts were passed. The Americans with Disabilities Act was passed in 1990. That's another big one, a large part of my practice. There is a whole lot of disability discrimination. We also have the ADEA, which is Age Discrimination in Employment Act, and that is for those who are 40 and over. And you also have some newer ones like for genetic information and so forth, but your big ones are going to be Title VII of the Civil Rights Act of 1964, your Americans with Disabilities Act, and then your Age Discrimination Act. So knowing that information, if you fall into one of those categories, then you can move forward and match the theory of law, the protected class, with what you're going through at work. And I know I'm making it seem very, very simple, right? Like, oh, that's all you have to do. That's it. That's all. It's no big deal. It is a big deal. And I understand that. And I'm standing with you. And although this podcast does not represent legal advice because I haven't spoken to you personally, I don't know your individual facts. What I can tell you that if you put on this mindset that I have time today, you're going to start training yourself to face the mistreatment, knowing that you have some resources behind you to move forward and fight. In the therapy world, anxiety is defined as an over-exaggeration of the threat and an underestimate of your available resources to combat the threat. So we're looking at the threat like, oh, that's too big for me to handle. I don't have the resources to deal with it. And I'm letting you know, you do. You do have the resources. You have this podcast. You have me. You have Felicia. And you have this knowledge that corporations have vulnerabilities. Like the HR director who leaves her calendar open and you can see that she's clearly meeting with attorneys today. Like, that's so sloppy. It's so scary. And you have to know that corporations do get scared like that. When I talk to people about what I do and how my mind goes into strategy mode, especially my friends who are business owners, they tell me, you terrify me. If I saw you coming towards my company, I would be scared. So let's not elevate corporations to this untouchable status. They have to answer to some things, and we're learning how to bring that fight straight to their doorstep. So going back to our goal, we want to be strategic. So I've already given you the 3 possible exits that you can take, going back to a calm work environment as the employer fixes things, or you can enter into a contract for a settlement, or you can initiate a claim for discrimination if the settlement doesn't work. Now, how do you know which one of these to go to? Well, calm work environment, when you approach your employer and they're not open to fixing things, you know that you're going to have to take some other more aggressive action. Now, here's a way to test if you can enter into a settlement agreement. Say, for instance, you've been dealing with this discrimination for a while and it's starting to get very bad and you're starting to feel it in your body. A law that the EEOC does not oversee is the Family Medical Leave Act, or FMLA. With that act, we are allowed to take up to 12 weeks of either paid or unpaid time, depending on how your PTO is structured at your job, but it could be unpaid, up to 12 weeks for a certain qualifying event. Granted, you have to have been working at your place of employment for 1,250 hours within the past 12 months to qualify. So you're getting sick because of the stress. Your body is starting to fail you and you have to go back to work every day. But going back to work every day is making the situation worse because that's where all the stress is. You can go to your doctor, get them to certify and take you out of work on FMLA and leave the job for a little while. Okay? I'm not telling you to be fraudulent, but I am telling you that stress actually causes physical ailments in your body. You get sick from stress. When you take time off, that is a good opportunity to either get with legal counsel or to start communicating with your employer about the reasons why you are stressed out and seeing what can be done. Now, a couple of things usually happen when you take time off like that. Number one, if they don't like you, but they need you, you'll start to feel that pressure, which is illegal under FMLA. They cannot discourage you from taking FMLA. But you can notice that if they're putting that pressure on you to come back to work, going back to a previous podcast episode, right? My value must be closer to a necessity. They need me there. They don't want me to take time off. Okay. Now you can leverage that. Now you know that they are willing to cross certain boundary lines in order to get you to come back to work. Then you just start collecting the evidence. Every time they discourage you, every time they try to sabotage you from taking time, all that is building a case. Now, FMLA is not directed by the EEOC. You don't have to file an EEOC claim for FMLA violations. You can go directly to the courts for that. However, almost always, FMLA has a disability claim under the Americans with Disabilities Act with it. So now you can start stacking these laws on top of each other, proving the ultimate point that your employer has an attitude with you because you're sick. And they're not willing to fix the things at work that can create a better environment for you. They'd rather put more pressure on you to perform instead of fixing things at work. That's one of the ways we set corporations up, to expose what's underneath, which is a heart to discriminate against you. And once that bubbles to the surface, you collect the evidence and now you have a claim. Now you can take that evidence back to them and say, listen, all of this evidence says that you are discriminating against me. How are we going to solve it? Do I get to go back to a calm work environment, or do we need to come to the table and work on a severance agreement? That's one of the ways you can tell which one of those options you need to take. Now, let's say you do that after gathering evidence that they've been discriminating against you and they refuse to fix it. And then they start retaliating against you because you even brought it to them in the first place. This can include even terminating you. Well, now you add a retaliation claim to that. Now it's time to take it to the EEOC. Now it's time to take some legal action against them. But guess what? Your case is stronger because you said something. Your case is stronger because you allowed their true colors to show through. You gotta have time today for this. You've got to think past the 9 to 5, the clocking in, the attitudes, the snarky emails, all the microaggressions. You have to think past that and think, how can I force them into a bigger move? And when you've got time, you don't put that pressure on yourself to just leave immediately. And that's what I'm trying to get you guys to understand. Don't leave immediately. You guys, this is bigger than just fighting back. This is about getting what's yours. There have been huge fights in this country for our civil rights, and we finally have some leeway. We have some law on the books that tells us that we shouldn't be treated this way at work. Let's use that to our advantage. You've got to have time today. I've got time today to stand up for my rights. This is about restoring our dignity as humans. When you're in the workplace being treated that way, you feel so low. You feel like trash. And that's not right. That is not why we pick ourselves up, go to work every day with hopes to supporting ourselves and our family. That's not why you do that. So you got to have time today to fight for your dignity. You got to maximize your time on earth. Like in the grand scheme of things, that legacy you're supposed to be leaving, this next generation that we're supposed to be bringing up and encouraging to carry on the torch, all of that depends on how we deal with today. So you've got to have time. You've got to have time for this today. It has been my honor to have legal therapy sessions with you. It has been invigorating and motivating and inspiring for me to not do what I told you not to do and just walk away from this area of law. You know, when I'm fighting cases and it just seems like my clients are not getting what they deserve, I get so frustrated. I'm just like, you know what? Forget it. I don't even need to do this. I don't want to be a part of the system. But I have to have that moment with myself where I have to decide, do I have time for this today? Am I going to show up? Am I going to stand up for what's right? Am I going to put the work in to actually fight? And so I think all the listeners of Trill MBA who right in that moment when I was ready to just throw in a towel, y'all said, Attorney Anitra, we got time today. We're going to do this. And so if you need to figure out if you're being discriminated against, I know this is our last therapy session today, but it doesn't have to be. I have created the AA Legal Therapy Masterclass. I've got 3 secrets for you on how to identify discrimination so you can protect your paycheck and your peace. So go to aalegaltherapy.com. I'm going to have information there on how you can get into this masterclass so that whenever you're unsure, whenever you have an inkling about being discriminated or treated differently at work, you'll be able to go through this masterclass and know for sure. And so you can decide to strategize. You guys, this has been a takeover of Trill MBA. I'm attorney Anitra. Peace.
The Trill MBA Show is a Fair World Corp LLC production. Executive produced by Felicia and Rose Inuha. Sound design and editing by Chris Mann with Podshaper. Theme music is Kick Push by Ryan Little. Keep it trill every day, y'all.